It is very unfortunate. Looking at the ruling that came from Supreme Court today, we never anticipated to have such a ruling. In fact, we in Assin North are very, sad, and it's a shock to us. In fact, like I said, we never anticipated this. Looking at the achievements of Honorable James Achikwesi as our MP, going through all these court cases, he has done extremely well when it comes to development in Assin North. It has appeared to us that, in fact, we do not have any representative, and now it has even happened that his records in Parliament should be expunged completely. For us, it is a sad news to us, and it's a shock. We do not know if you will get a person like Honorable James Achikwesi, because a man of his words, a man who has come to help the community. Now, if you come here at Simbreku and even its environs, you could see the handiworks of Honorable James Achikwesi. I can tell you, if you are going to wait till night, you will see that the town is full of lights. And this is because of Honorable James Achikwesi.
Because only me
the matter has been decided fairly because you can't stay in Ghana and continue to stay abroad. If he was only a Ghanaian citizen, there wouldn't have been any matter. It's just because he had dual citizenship. Next time, if you are doing something, do it well, so you don't get caught up with the law. The person that petitioned the court has done no wrong. Next time, if you are abroad and you want to contest, make sure you have the required documents.
Next time, it's our brochure now. Over your people, and son, a maniacal. Eh, pa. Nay, that's sorry, and Tiasampa. As I'm saying, me rock, papa. Was Papa by say, or the boy, or master of the boy, no. We are
deeply pained by the decision of the court to expunge his records from Parliament. He's indeed been very supportive of all activities in this constituency. The development is a huge loss to us. Ever since he came here, he's been very helpful and contributed to many social events, including funerals. Even when he had not become an MP, he still helped with many construction works. We're hoping he was going to help us deal with our unemployment issue when he became a member of Parliament, only for him to go through all this.
Assin North.
James Achikwesi's eligibility as a member of Parliament has been in contention since he won the 2020 December parliamentary elections. The matter has gone to the High Court, the Court of Appeal. There's an aspect of it that is also at the High Court in terms of a criminal matter. But some finality has been brought to it, as the Supreme Court has by unanimous decision ruled that he was not eligible to contest the 2020 polls. The court, presided over by Justice Jones Doche, also held that the Electoral Commission acted unconstitutionally when it allowed him to contest the parliamentary polls without proof of renunciation of his Canadian citizenship. The court then issued an order asking Parliament to expunge James Achikwesi's name from its records as a member of Parliament. And so this is the decision of the Supreme Court, and lawyers for Michael Ankuman Infan, led by Frank Davis, are excited by this decision.
We have to protect the sanctity of the Constitution, and we are gratified that the law lords, all the 7 of them, have agreed unanimously with the position we have held all along, that at all times material, James Achikwesi was not qualified under the dictates of the Constitution of the Republic to have contested as a member of Parliament for the Assin North constituency. It's been a long road. You can all attest to the number of times we have paraded the court premises. But today, finally, the judgment has been handed. And we have a clear indication as to what the provision on dual citizenship is in respect of a contest for member of parliament.
And what do you expect to happen practically going forward? The court interestingly gave an order that his name should be expunged from the records of parliament.
Of course, but that is a necessary consequence of the reliefs that we sought in the Supreme Court. If he wasn't qualified to have contested as a member of parliament, of course, the necessary inference is that whatever happened was null and void and of no legal effect whatsoever. So Parliament cannot still keep his name on their books. It's a necessary consequence, but of course the order has to be drawn and served on the Speaker, and his name will have to be expunged. That is the constitutional injunction on the EC. So my client is not looking forward to anything. The EC will have to comply. Insofar as that seat now remains vacant, the EC has to conduct elections in that constituency. So it is not for my client to be looking forward to. It is for the EC to comply with the orders of the Supreme Court. And the constitutional injunction is that if a seat is vacant, you organize fresh elections.
And so the lawyers expect the orders of the court to be drawn up and served on Parliament, and that the Speaker will declare the seat vacant, after which they expect the Electoral Commission to proceed to organize primaries. For JoyNews from the Supreme Court, my name is Joseph Akable.
Well, so that's my colleague Joseph Akable with a wrap of what happened in court there. Let's join our guest and go delve into this particular matter. We've been joined by Gary Nimako, who's Director of Legal for the New Patriotic Party. Edwige Tamaklo is a member of the legal team of the National Democratic Congress, the NDC, and Samuel Bing is with the Parliamentary Network of Africa. Grateful to you, gentlemen, for joining us here on the AM show.
Hello, good morning.
Great to have you. So let me start with you, Samuel Bing. Sami, with what has happened, what do you reckon will be the impact on parliamentary duties?
Well, good morning and good morning to your cherished viewers. Well, Parliament is being on recess. We know that for the last 1 year, the people of Assin North have not been represented in Parliament because a member of Parliament had been stopped from, attending to parliamentary duties. We are expecting that the court will serve the Right Honourable Speaker on these terms. Of course, once that is received, certainly the Clerk of Parliament would announce to the EC or inform the EC about this. And then the Constitution, as enshrined in, I think, Article 112 of our Constitution, 1125, says that within 30 days, a by-election should be held. So it's expected that all other things being equal, there should be a by-election held in this regard within, the month of June, early July. Certainly would not have too much of a toll on what would already be happening in Parliament. The people have been, denied representation already for about a year because of the court issues and what have you.
Okay. Do we also take it that by saying that his name should be expunged, it means all monies paid to him because of his membership will be taken back from him? Is that what the meaning is?
Well, I'm not too sure about that. Okay. Perhaps the lawyers in the room may be able to...
Fortunately, we are with lawyers, so...
For those periods, he served as a member of Parliament of no fault of his. It is now that the Supreme Court has determined. I'm not too sure that it will take retrospective effect and say that, look, all monies paid to you by Parliament should be taken out. Certainly, the courts were very clear that his name should be expunged from all parliamentary records, which means that never would it reflect that in this 8th Parliament, there was a member of Parliament called Jesse Kwesi, unless, of course, he gets the opportunity to come back to Parliament, through a by-elections, perhaps.
Okay. Let me start then with Gary Nimako. Gary, so
the question I wanted to get clarification from Sammy, then if you can help me understand. By expunging his name from the parliamentary role, does it mean that it should be taken that he was never an MP and that any benefit that had accrued to him by virtue of that position will be taken back?
Well, good morning and good morning to your cherished viewers and listeners. I don't know whether you can hear me. Can you hear me?
Yes, perfectly.
All right. I think that basically this gentleman in the first place ought not to have been in parliament at all. The foundation of his presence in parliament was weak. He knew very well. I'm surprised my brother is saying that he did not for the of his. He knew very well from day one. He was not supposed to have put his name up for elections because at the time when he put up for elections, he was holding on to the Canadian citizenship. Yes, an application had been made before, but he ought to have waited to get a civil renunciation before filing. The law had been very clear all this while. The NATO had made it very clear all this while that at the time of filing, at the time when the EC opens nomination and you are going to file, you must ensure that you qualify under Article 94 and also Article 45. Clearly, the gentleman had made an application to the Canadian Embassy, all right? But at the time of filing, he had not been given certificate of renunciation. So the application was still pending. Now let's walk through a process. People will understand. It is not for nothing that people apply for citizenship. Now, when you go into a foreign land, depending on how you go, whether you enter through a marriage application, student visa, business visa, whatever it is, it goes through a process. It goes through a process. Now, it gets to a stage whereby you have been given what we call indefinite leave to remain, or what they call green card. At that stage, you can decide to remain a green card holder. You can decide to remain an indefinite to remain holder. It means that you are still holding on to your Ghanaian passport. That's what it means. It means you have the Ghanaian passport and you are still holding on, and you have the Ghanaian passport alone. And you have the permanent residence. Now, when you decide to migrate into a citizen, the different thing altogether. If you want to acquire all the rights as a citizen of that country, all the benefits of that citizenship of that country, all the obligations of that country. So you go to what we call naturalization ceremony. Ceremony takes about 15 minutes.
Yeah.
Now, when you go to do that ceremony, you will now go and pledge allegiance to the sovereign. To the sovereign. You swear an oath. And you pledge it to the sovereign. Now, in Canada, for instance, then the Queen of England, but now the King Charles III, that you will be faithful to the King, and that all his heirs, successors, and that you faithful to and observe all the laws of Canada and fulfill any obligation thereof. This ceremony you go through, after you go to the ceremony, then you are given what you call certificate of naturalization. Then you are now given a passport of Canada. If the UK, you be given a UK passport, American passport, if the Ghana, Ghanaian passport. That's the procedure. Now, the law is very simple. The current position of the law now is that once you go through that process, you are not entitled to hold any position in Ghana. One of them is Chief Justice, Director of Immigration, Director of Prisons, Cabinet, Member of Parliament. It goes on and on and on and on. And somebody tells me that when you apply for a dual citizen, and that you go to certificate of renunciation, and you apply that you want to renounce, the photo of application simply means that you have already renounced. And I said, wow. So when you apply for visa, and they are giving, you say you want to go to UK or to Canada, and the application has not been granted, you go and take a plane and say you're going to Canada or to London or to wherever. Is that the process? Absolutely no. You went to get a visa first.
But aren't those two different?
It can be denied. Hello?
But aren't those two incomparable? This is someone who's a citizen of Ghana by birth and by the fact, virtue of the fact that his parents are from Ghana, and then went to take on another citizenship of another country, and then he's put in the application to renounce it. First of all, he still holds his Ghanaian citizenship, isn't it?
Yes, he holds it.
So by the virtue of him starting the process,
the point I'm making is that the application for renunciation can be refused.
Okay.
Are you aware of that? It can be refused. There are conditions for the grant of the renunciation. Under Canadian law, it can be refused. Even in Ghana, it can be refused. So you have to wait until you have got the certificate of renunciation before you can progress from there. So the fact of putting an application does not mean that you have been given the certificate of renunciation. It can be refused. It can be refused.
Okay.
If, for instance, you are somebody who you are in a country and they realize that you are a person who can be of extra charges, they will refuse it. If you put an application, you don't put the required fees, it will be refused. The required documents, it will be refused. If you put an application and you have to go for interview, all right? If at the embassy, if you are outside Canada, you go to the embassy where you live. If you go for the interview, it can be refused. So don't they make the argument that when you put an application, it means that you have renounced it? I don't understand that that argument. I don't get it. It can be refused. So you have to wait. So Question's case, what you ought to have done was you have waited patiently. When he gets the certificate of renunciation, which he got on the 20th of November, before the elections, then you can now put in what? The filing processes. Clearly, before the file of 1994, I made it very clear that at the time when you are filing with the EC, you ought to have been qualified within the meaning of the 45 and 94, which means that you do not owe allegiance to any other country other than Ghana. And that you're a registered voter, blah, 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 you don't owe taxes, blah, blah, all this must be there. Let's not forget that until the amendment was done, if you had a dual citizenship, you cannot hold a Ghanaian passport. And then the amendment was done to allow Ghanaian citizens to hold on to foreign passports at the same time hold on to Ghanaian passports. But the law said, as far as Ghana is concerned, they will not allow you to hold certain positions in Ghana. That is the law. That is the law, and that remains the law until such a time that the law is changed. That remains the law. So, I mean, I really do not understand why somebody will tell you, oh, you know, he put in the application, so the intention was that he's renouncing, and so therefore he has renounced. No, 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 no. You should go and check. And when they go and check, they realize that even to be eligible to file, there are conditions attached to it. Even to be able to get application to go through, there are conditions attached to it. The number of days to go through are all stated there. On the Canadian website, it is there. You should go and check. So the fact that you put in application to organization does not mean you have renounced. It doesn't mean that. So Kwesi knew that all this while, he wasn't holding on to the Canadian citizenship. So to have filed for application and say that, well, I'm filing with the EC. And then you make a declaration that I do not owe allegiance to any other country other than Ghana. On the solid declaration, under oath, I do not owe it to any other country other than Ghana. You made that declaration under oath on the EC form. When you knew, or you ought to have known, that declaration was false, and you were making that declaration. I mean,
but he got his renunciation certificate on the 20th of November. 17 or more clear days before the election, which he won. So at the time the constituents were choosing him as their member of parliament, he was a Ghanaian and not owing allegiance to any other country. Why don't we consider that particular one? That the fact that at the time he was being elected for, he was a Ghanaian and not holding allegiance to any other country. We could give an exception to his case.
No, let us understand that election is a process. You don't go through elections by just going for the ballot day and say that you are going to contest elections. It's a process. It starts with the filing of nominations. It's a process. You file nomination first, and you now go and print your posters and now go and campaign, and then your name is on the ballot. Notice for pool is published out there. And then on the day of the elections, you go and campaign. After campaigning, whatever you win, and whatever it is. You don't just say that before the elections. At that time, it was only a Ghanaian, and so therefore, we should block our eyes and say, well, nothing has happened at all. At the time of filing, that is the crux of the matter. At the time of filing, Article 45 combined with Article 94, it kicks in. It kicks in. And when you go ask my friend Tamaklu, he will tell you, when we're doing this case, the not charging my Rollins, that's party, by the Supreme Court. And I was telling him that, look, Tamaklu, this thing that you people are doing, the not thought they have voter ID card. Okay? So the party people were complaining that they've allowed the not to contest party primaries without voter ID card. With the Supreme Court. And the Supreme Court said the question that at what point in time that Article 94 kicks in, 94 and 45, you answer the question. What point in time does they kick in? Is it a time when the political party are doing their primaries, or at a time when you are actually filing? And the court made a different pronouncement on the matter, that it is at the time of filing, and that all that we are doing is a expression of intention. So you cannot disqualify anybody at the party primaries. The person comes there, and then the person is holding on to dual citizen. Don't disqualify the person. Or voter ID card, don't disqualify the person. Let him go through it. And when you are about to file the person, then you must show that the person qualified within the intendment of Article 45 and 94.
Okay. Okay.
So you cannot close your eyes to the time of filing. Filing commences the process of the entire listing. When you file nomination, you ought to have qualified that indeed you don't owe allegiance to any other country other than Ghana. You have paid all your taxes in full, your voter ID card, all the list. You are not a convicted felon. Everything they said there should take effect. So this is a matter that I think should put to rest.
Okay.
I've done the Zenato Rollins matter, and then now this has come in. I think that this matter should put to rest.
Okay.
Mr.
Let me bring in Edwidge Tamaklo here. Let me bring in Edwidge Tamaklo. You referred to him in one of the cases you did together. Edwidge, grateful to have you here. Now, this is a done deal, isn't it? The law was specific that you cannot become a member of parliament if you owe allegiance to a country other than Ghana. So in this case, that was Mr. Quayton's case. It's not something that is plain in law.
Okay, so once again, good morning to your cherished viewers. Now, with this said, I need to point out that what happened yesterday at the Supreme Court was an application of a very restrictive tool of interpretation without the duly elected MP for Assin North. What is not in doubt is that the will of the people of Assin North was not challenged. What was not challenged? The fact that he was duly elected by the majority of the people there. What is in doubt is whether or not he, J.P. Quayton, by reason of Article 94, 2A, he is qualified to be or elected as a member of parliament. And my brother, just for ease of reference, let me just quote to you verbatim what the constitutional provision is. Please. It says that a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana.
Yep.
Or good. So the constitutional provision under attack is the word owes allegiance. Correct.
Sure.
Now, it's important to make this point, and people have confused the two, that the constitutional injunction is not against dual national or dual citizenship. The Constitution carefully the preface of the Constitution uses the word allegiance. How in God's name do you say citizenship is synonymous with allegiance? How in God's name do you say that being a citizen means automatically you owe allegiance? It would be bizarre. Do you know why? Rather, in 1992, when the NDC put forward Mr. Jerry Flight Lieutenant as its presidential candidate, the private citizen by name Hilton went to the court and said, listen, don't allow Rawlings to be the NDC presidential candidate. What were his reasons? That it is a notorious fact that Rawlings' father is Scottish or Irish. So USA is from the United Kingdom. And so by reason of this, Rawlings needed to show a certificate of renunciation of his UK citizenship before he should be allowed to contest. Even though it was in the High Court, the High Court judge demonstrated in a very seminal ruling that, listen, if the contention of the plaintiff is that Rawlings needed to go to the UK High Commission to obtain a certificate of renunciation before he can contest as a presidential candidate, it would be bizarre. Because, like the judge reasoned, Rawlings, having joined the Ghana Armed Forces in the 1960s, okay, had taken the oath of allegiance to Ghana and only Ghana. Not only that, when he did the 2 coups, again, he took the oath of allegiance to this country. So the judge looked at the circumstance, the peculiar circumstance, and concluded. And that is how come the injunction that was brought by Bilton to stop the Rawlings, and that provision is the same as this provision. At that time, it was the PMDC law, which was to be used for the election then. That law has been transported. What lawyers will say is inquiry material with Article 94(2)(a), the same provision. So the operative word there is allegiance, not citizenship. The premise of the Constitution did not say that a person shall not be qualified if he owes allegiance, he is a citizen of a country other than Ghana.
But lawyer, how do you determine one's allegiance to a country other than his being a citizen of that country?
So for instance, there is what you call the animus, then the act. Now listen, if I have, for instance, I have an American passport, right? I write a letter, put the American passport in an envelope. Together with the letter, I go to the U.S. Embassy and say, America, this is my passport. This is my date. From today, I don't want to have anything to do with you. You are telling me that unless the Americans accept, I still owe allegiance to them. It is not citizenship. It is allegiance. Two distinct matters. Unless, of course, you are telling me citizenship means allegiance. Is that what you are saying?
But my question is that how do we determine allegiance here?
It's an engagement. It's an engagement
Sure.
with respect.
Sure, yeah.
Yes, it's an engagement.
Sure.
Unless, of course, your proposition is that citizenship means allegiance. Is that correct? Is that your position?
No, but the question I was asking is, how do you determine allegiance?
You to help me here.
Uh-huh.
I want to know what exactly you are driving at. So that, for instance, your contention is that citizenship means allegiance. Is that correct?
That's my understanding.
So how come that the same constitution, where a constitution and its framers want to use citizenship, they use that. Where they want to use allegiance, they use that. How come? How come that they didn't say it's interchangeable? How come that are we importing citizenship into where allegiance is? How come are we doing that? In any case, this particular case raises some interesting perspectives. And permit me to run you through them. I beg.
Kindly do so.
Yes. First of all, a petition was filed against the situation at the High Court case. Correct. And an application for injunction duly filed. At the hearing of injunction application, thankfully, our law firm at that time was representing the situation. My learned senior, Gary, was involved in that process. At the injunction there, we had raised obvious constitutional interpretative matters, as I have indicated earlier. At the proceeding, my learned friend, my learned seniors, representing the petitioner then, when we said there were serious issues of interpretation, and for that matter, the High Court, by reason of Article 132, to stay proceedings and refer the matter to Supreme Court for interpretation. My friend who was representing the petitioner opposed the application for referral. It didn't end there. When the substantive matter, at the hearing of the substantive matter, we again raised these fundamental interpretative matters and said, look, by reason of Article 132, the High Court judge will refer the matter to Supreme Court, so that whatever the Supreme Court will say will be binding on all of us. Again, my learned senior and the other lawyers for the petitioner opposed the application, saying that the provision is clear and unambiguous, blah, 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 blah. Interestingly now, the judgment of the High Court, my learned senior here happened. High Court judge said the provisions of Article 94(2)(a) are clear and unambiguous, and so there was no need to refer the matter to the Supreme Court. Actually, even when we applied to the Court of Appeal, to the Court of Appeal, we again raised the issue of constitutional interpretation. There again, the lawyers for the petition opposed this application for referral and said the provision is clear, unambiguous, and requires this interpretation. Now look at it. In a very miraculous manner, the same lawyers who had opposed the application for referral at the High Court, Court of Appeal, suddenly now issues a writ at the Supreme Court asking for interpretation. What happened? What happened? What is it that happened that we don't know? What is it that happened? That suddenly the people who have opposed the application for referral, of which the High Court has actually agreed with them and said the provision is clear and unambiguous, subject issues a writ at the Supreme Court, asking the Supreme Court to interpret the same Article 124(2)(a). It looks strange to us. We are baffled at the sudden Damascus moment by the lawyers. Strangely. For the first time since 1992, for the first time, since 1982. A court in this country has granted an injunction to restrain a member of parliament simply because a writ has been filed or issued before the court. We find it extremely strange. But that's aside.
Well, Eduji, I'm sure, and I know, of course, you are aware of it. The former Boko Central MP, Adamu Sakande, I'm sure you remember him. How different is his case from this?
If you go Adamu Sakande's perspective, it will open a can of worms. I beg.
Oh no! I mean, we're having a discussion, and I'm asking that how different is that case from this one?
Listen, my friends who are NPP members have always relied on Adamu Sakande.
Okay.
And it gives me an idea that it may be like using the court system for revenge. First of all, and to his dead memory, you see, he's a dead person, so I want to be very cautious and to respect his memory. First of all, Adamu Sakande, even because he was MP, so had his Burkinabe and UK passport. In the case of JTP, which is very important, citizens of Assin North, carefully, some citizens of Assin North, calling themselves concerned citizens of Assin North, have put together a petition against JTP before the election. Now, when they put this petition, the petition went to the district issue officer. He said, look, as sponsors filing, this matter is too big. It was escalated to the region. The regional issue officer also said, look, this matter, we can't take a decision on it. So it was further escalated to the office of Madam Jane Mensah. When this petition got to the office of Madam Jane Mensah, Madam Jane Mensah, through her official, told the person and said, look, we have a petition against you, and these are the grounds. What says that? The situation then gave the indication that if this is a concern raised by these people, this is my certificate of renunciation. Then the election commission, upon scrutinizing the certificate of renunciation produced by the situation, now said, Mr. President, you can now go ahead and contest the election.
Which month did this happen?
This was in November.
The filing was in which month?
No, the EC opened nomination in October. So when the nominations were filed and put in his application, these citizens of Assin North then said, look, we have to believe that he is a dual, he has a citizenship of Canada, and that he has not renounced or denounced it. So they got a petition. My question is this: if you are saying that nomination process, the nomination is what kicks in the qualification conversation, right? How come that the electoral commission, the body mandated by the laws of this country to organize elections, called him upon the receipt of the petition for further scrutiny? What it means is that the nomination had not stopped. In any case, this same Supreme Court, respectfully, has earlier decided in the matter of the Republic, the High Court, as Party Indu, Electoral Commission interested party. If you recall, Indu and Co were disqualified by the EC. You remember that incident? You remember that incident? Good. So at that point, the Supreme Court ruled The nomination is not an event. It is a process. And so, for instance, when you file your nomination, the Electoral Commission can take a decision on your nomination, whether you are qualified, whether you are not, must give you a hearing. You remember? So it was the failure, but in any case, that case, Malene Senior, David Mako, was one of the lawyers for private kingdom. And the argument he and my senior Ayiko Otu made before Justice Chambers, then at the High Court, was that their client ought to have been heard before the EC will take a decision on their qualification or disqualification. And the matter ended up at the Supreme Court. The Supreme Court now ruled that nomination is not an event, but a process. And so, at the time the EC purported to have taken a decision on the disqualification, at least they ought to have heard in due and co. And that is how come the disqualification of Indum and Co. were all set aside by the court. What has changed in the case of the situation? Where the undisputed fact was that the EC called him and said, this is a petition that we have received on your nomination. What says that? The man then produced the certificate of renunciation. Then the EC said, we are now satisfied. Go ahead and contest. That is the truth.
Okay.
That has never been disputed.
Okay.
So that is why I am saying, and let me make it clear, that what the Supreme Court did yesterday was to apply a very restrictive interpretation of Article 94(2) without regard whatsoever to the peculiar circumstances of the situation. But like the party...
And what are those peculiar circumstances?
No, first of all, like I gave you, the fact for the court, without dispute, was the fact that the situation by the EC's own doing has been called to respond to the petition.
Okay.
In the case of Sakandi, was every person that?
Let me bring in your colleague Gary here. Gary, so the law was not specific as to which period within which you have to renounce your citizenship. It says that, subject to provisions of this article, a person shall not be qualified to be a member of parliament unless he is a citizen of Ghana, has attained the age of 21 years, and is a registered voter. Now, a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana. There is no period within which the person should renounce. For example, this man, by the time we were going to vote, had renounced his citizenship with Canada. So why are we holding him to that when the law was not specific as to when he was not supposed to have renounced?
After referring to all the authorities, surreptitiously refused to refer to an authority in a matter that he himself did with me. Yes, he should have mentioned the authority. That is ex parte Senator Rollins. The period was set in that case. The period was set in that case. Ex parte Senator Ajiman Rollins, which was done by Leonard Counsel Edudi Tamakulu. The period was set that it should be at the time EC opens nominations for filing.
Okay.
Why come in that case he didn't mention that case? Because you know, you know that time when the court said that the period start from that time, Tamaklo at the time realized that Donato had no voter ID card. They kept dragging their feet back and forth. Immediately EC open nominations for voter
registration.
Quickly, they went and registered the senator, and they got the voter ID card to the Supreme Court. My brother Tabaklo was holding the voter ID card. He entered the court and said, "My Lord, this is a voter ID card. This is a voter ID card. This is a voter ID card." Yes. And therefore, the opportunity was open for the senator to now go and register, and then so to go and to file the nomination. How come that case is not referred to that case? Because the period was set to that case. That at the time of filing with the EC, you ought to have qualified within the 45 and 94. I.e., when EC open nominations, make sure that you're a registered voter, that you are a citizen of Ghana alone, you pay all your taxes, you are not a felon, committed felon, blah 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 blah. They are all there. But that's my very question. He couldn't answer the question. If you are a foreign national and you want to acquire citizenship in another country, if you do not swear oath of allegiance, there is absolutely no way that you'll be given a foreign passport. There is no way. And let me repeat again. If you're a foreign national, you're a Ghanaian citizen, you want to acquire a Canadian citizen, a UK citizenship, American citizenship, and you don't go through the ceremony of nationalization and so the oath of allegiance, there is absolutely no way that they'll give you renunciation and then give you the passport. There's no way. There's no way. So it is a policy precedent. I.e., you must go to the ceremony first. When you go to the ceremony and you swear the oath of allegiance, then you are given certificate of what they call naturalization, and then you are now given the passport. In the same vein, if you want to renounce, you have to renounce. Put the application for renunciation, you will put in the application, you renounce. You are given certificate of renunciation, and you are free to go. As I said, the application is it can be refused. It can be refused. And it is very clear. If you check the Canadian law, it's not very clear. It can be refused. So it's not as if once you apply, then it means that, like, say so simply, no, just put in your passport in an envelope, send to the American embassy and say that, oh, I have renounced. So that should end the matter. No, that's not the law. It's not true. You ought to go through the process first and be given a certificate before you are free to go. But as I said, if you are somebody who, for some reason, they didn't believe that mentally, you don't even understand what you are doing to renounce, they will not agree. Now you are somebody that they believe that you are not 18 years and above, they will not agree. You are somebody they believe that at the time of even renouncing, there were some obligations that you are owed the state. They will not agree. If you are somebody they believe that you are not paying the required fees, they will not agree. These are all criteria set down by law. They are also done by law. So you must go to the process first. And like you rightly said, elections is not an event. It's a process. That's the correct position of the law. It's a process. The purpose Hindu was disqualified because they said that he has filled forms and make like out of the forms. And he wasn't given a hearing by EC. We challenged the conduct of the EC then. The High Court agreed with us. They said no. They went to the Supreme Court. The Supreme Court said no. What you are doing is wrong. You ought to give them a hearing. I.e., you ought to have heard them before what? Disqualifying the person. The purpose Hindu's case was not about dual citizenship. At all. Far from that.
Well,
far from that. So as for the dates and the time, already it has been set by the case of ex parte Senator Ajiman Rawlings, of which counsel for the Senator was Tamakulu, my own brother Tamakulu. So let me speak to that case. So now I've been telling him, when I meet him, I said, look, yesterday it was your turn, and you were happy, and you came to the court with an ID card, and you were happy. But today, why are you not happy this time? The same law has been applied.
Okay.
Nothing has changed.
The NDC
has been applied.
The NDC has released a statement in which they say, quote, in the light of many previous decisions that we are aware of, including decisions in cases involving Honorable J.H. Mensah, Honorable Baba Jamal, and Honorable Peter Amewu, that state that the Supreme Court does not have the jurisdiction to invalidate a parliamentary election, and that the High Court is where such a matter should be taken. It seems strange to us that the Supreme Court gave this decision. Moreover, there is no doubt that the Honorable James Jachikwesin did not owe allegiance to any other country, whether at the time of his nomination, election, or swearing in. We also look forward to seeing the reasons for the court that the court will provide on court there. What's your response to such a matter where they say that the Supreme Court is not supposed to be hearing such matters?
Let me simply explain that what was before the Supreme Court was not about election petition. It was not election petition. What before the Supreme Court was about qualification and eligibility, Article 94. Interpretation and enforcement. It was not a petition. They shouldn't confuse anybody. Okay? They had gone to the Supreme Court the same way tobacco went to the Supreme Court for enforcement. Okay? And interpretation. What was before the Supreme Court was for qualification. Whether or not Mr. Kwesi at the time of filing was eligible, whether he was qualified to have been allowed to file by the EC in the first place. That was the question for the Supreme Court to answer. That was the question. And you see, you can't put something on nothing. You can't put something on nothing. If the foundation is weak, everything will fall on it. The foundation of Mr. Kwesi's application, filing and everything was weak. Simply put, at the time when he was filing, in October 5th or so, he was still holding on the Canadian citizenship. Now, at the time when he obtained a citizenship, he had already filed. The boats are already voted. He had already filed. And so, therefore, he ought not to have been allowed to file in the first place. Look, this matter was an internal NDC matter. It's NDC members who raised this matter with the executives. And, you know, like political parties, sometimes they just ignore them. They ignore them. They raise the matter in their own internal elections, primaries, and they ignore them.
Okay.
Now, the EC, in my view, made a mistake by allowing the question to file. Sorry, to more or less contest. When it came to their attention, that at the time of filing, as a matter of fact, he had perjured himself. But we go look at the form. You will see that he said that at the time of filing, he owed no allegiance to any other country other than.
Okay. Let me turn to Eduji now. Eduji, your party says, quote, nonetheless, even as there are serious questions about the legitimacy of this decision, after consultation with Honorable Kwesi, the leadership of the National Democratic Congress wishes to state unequivocally that we are ready for the by-election. That is now the result of this decision. The full weight of the party, including the minority caucus in Parliament, will be put behind Honorable Kwesi so as to ensure an even more resounding victory for him in the upcoming by-election. Question is, by this decision of the Supreme Court, does he still qualify to run in this by-election?
Hello?
Eduji?
Yes.
Yeah, I can hear you.
So let me read a particular law for you.
Okay.
You know, in Ghana, we have what we call the Representation of the People law, which basically governs parliamentary election contests. It's the most unique, specific law on parliamentary elections. And the law clearly provides, and let me read with your indulgence. It says, quote, Section 20, grounds for cancelling election results. The election of a candidate shall be declared void on election petition if the High Court is satisfied. Now, I want to go to the details. That the candidate was, at the time of his election, a person not qualified or a person disqualified for election. My brother Gary confuses the issue with what happened in Senator. In Senator, this is what happened. He had brought a suit for some people against Senator and said that within the meaning of Article 94, Senator was not qualified. You understand? By reason of the fact that he did not have a voter's card. I counted and said no. The question whether or not a person is qualified or not to start when the EC opens nomination. And the Supreme Court said yes. Because at this point you are dealing with internal party conversations. By relative to the 1992 Constitution, the conversation should start when nomination opened by the EC. That is different from saying that nomination closes the process. No. And he himself today has admitted that the question of nomination is a process and not event. And that is why his client, Dr. Indu, even when the EC had disqualified him after filing nomination, the Supreme Court said no. It's a process. The process only when the EC says so. In the case of the situation, even when he found his nomination and petition came, by the reasoning of Gary, it means that the EC had no business even contacting him. No. He himself admitted that in the specific case of Hindu, the Supreme Court faulted the Federal Commission that when it came to the conclusion that Hindu was not qualified and had to take a decision on his disqualification, you ought to be heard. In this specific case, if you read Article 94, 2A, together with the representation of the People's Law, Law 284, particularly section 20G, it says that, look, that the candidate was at the time of his third case. Ask Gary whether this is not in the law.
I take it that Jachikwesin can still run for parliament and that he will contest in this by-election.
Even from what Gary said, Gary's contention is that the only reason why the Supreme Court invalidated this election is that at October, when the EC opened the nomination, he didn't have the certificate of renunciation, correct?
Yeah.
Today, as we speak, the EC will definitely open nomination before there will be a by-election, correct? So, if the EC opens nomination today, they might have the certificate of renunciation already. So there is no back against him.
Okay.
Back to square one.
Okay, all right. But you know there's a criminal aspect of this if the Attorney General decides to pursue it. So would you still allow Jachikwesin to go ahead?
Let me set a record straight, I beg you, so you don't confuse anybody.
Okay.
I beg you.
Okay.
Already, the criminal trial is ongoing. Listen, in the wisdom of the framers of the Constitution, who are wise, possibly than us today, they envisage a situation where you can have I say this advisedly without, reference to any particular office holder. You can have a very mysterious Attorney General who can decide that, look, let me prefer frivolous criminal against opposition MPs. But in the wisdom of the framers of the Constitution, prosecution had never been a bar. And so if you read Article 24, and if you indulge me, so that I put this matter in proper.
We need to wrap up. So
no, 30 seconds.
That's fine. That's fine. Wrap up for me.
Yes, using the word oath allegiance or have been adjured or otherwise declared as we speak, there is no judgment relative to criminality against the situation. And in fact, if you look at the Supreme Court decision in Rosemary and Pan Kelly, Attorney General and others, the Supreme Court made it clear that there must be conviction, not prosecution.
Edwige, I'm grateful to you for making time for us this morning, and to you, Gary Nimako, I'm grateful to you as well. Sammy, I may probably give you the last word here. So, how do you expect Parliament to move on from where we are now in the next 1 minute?
Well, like I indicated, certainly Parliament will have to be officially notified about the ruling of the Supreme Court. Certainly, now that the NDC party had given indication of its unwillingness to pursue the matter further, by-elections will have to take place. It promises to be an interesting by-elections because of the dynamics of Assin North. But I'm sure that at a later date prior to that, we can be able to discuss that, because that's a constituency that has never had, since it was created from 2012 elections, had never had an MP win for more than a term. So it's always had a one-term MP from that particular constituency. And then the dynamics of the MPP NDC in that constituency makes it for a very interesting place for a by-election. So we look forward to that and see how it goes. So that at least the people of Assin North will finally get representation, because they've been denied of it for more than a year, which for us as a think tank on parliamentary related matters, it's not good enough. Okay, thank you so much. So Gary Numako is Director of Legal MPP, Edu Tamako is a member of the legal team of the NDC, and Sami Obings of the Parliamentary Network of Africa. Grateful to you gentlemen for joining us. This is the AM show. We'll just take a quick break. We'll be back with more to talk about IMF and matters arising.